up with this hopefully as we're going through this, and maybe share it later for those that maybe couldn't get online to join us. I'll be glad to share this information with them as well. But again, thank you for coming in and wanting to attend and learn a little bit about this. I'll kind of introduce Tiffany here, and you may not see her, but you see a picture of her and her family there, but that kind of helps keep everything a little tighter as far as the internet. It doesn't log down quite as much maybe. But Tiffany Lashman there, she's associate professor and extension specialist for ag law up out of the Panhandle area. And she does lots of different information and recordings, and she has a blog she does too as well. Lots of email stuff that come up, stays on top of everything pretty well for us. But I know Tiffany, I guess you're originally from New Mexico, but you can kind of explain a little bit about yourself too. But I'll turn it over to Tiffany and kind of let her kind of go from there. But you know, this eminent domain, just keep in mind, we're going to try to do a few others through the year as well via webinar or Zoom here. And so keep in mind, kind of watch your emails. We'll do some other exciting stuff as well. So Tiff, I'll turn it over to you.
Great, thanks, Justin. I appreciate Justin having me, and the work that he does to put on these kind of webinars. I think it's really an asset for you all to have him in your county and to have this kind of programming. So I appreciate the chance to be here. Like you said, I do live in the Panhandle. My territory kind of for my job at A&M is the entire state of Texas. And so it's kind of a big job, but currently we're grounded. And so I'm at home here in the Panhandle. I will tell you that in the other room, I have got a 3-year-old and a 4-year-old who have been instructed not to interrupt unless there is an emergency involving blood or fire. Although I just got off of a webinar which I had to pause in the middle to remove a marble from someone's nose. So you just never know what's coming over here. So with that, I will tell you, I'm an extension ag law specialist, so I am an attorney, and I try to provide educational information for landowners in Texas on kind of key agricultural law issues, of which eminent domain certainly is one of the major issues that we're facing. And so I give a disclaimer when I speak. Basically, it's just I'm a lawyer, I'm not your lawyer. And so while I'm more than happy to answer questions, if you all want to put questions in the chat box, I'm glad to watch that as we go. So if you have questions, type them in. I'll try to leave some time at the end for questions as well. I cannot offer any specific legal advice. You would need that from your own attorney. And so here's kind of a roadmap of what I'm planning to cover today. We're going to do just kind of a basic overview of eminent domain law. Then we're going to spend some time talking about the condemnation process. And I think that's important because if you understand the process, I think that just empowers you to better handle yourself and better protect yourself in that process. We'll look at some negotiation tips, and then we're going to hit on the topic of what is adequate compensation. So that's kind of where we're headed. I do want to mention to you a couple of additional resources I've got, and I'll show you where you can access them for free. One of them is really new. We just kind of released in the last couple of months a landowner's guide to eminent domain. Texas Farm Bureau sponsored that. I authored that. And our hope is that it's really just a good resource for landowners, written in, not lawyer speak, regular person language, that just kind of pulls everything together in one place. You can access that on my blog, and I'll show you how to do that at the end of the program. I've also had several podcasts we've done related to eminent domain, frankly, with some of the best eminent domain attorneys in the state of Texas. Those are free to listen to. You can listen on your phone or your computer. I'll show you that at the end as well. So that's just some extra info if you want to do some homework after the program today. So just basically, what is the law regarding eminent domain? That should say condemnation, not compensation. Sorry about that. So basically, the law that relates to eminent domain is found in the Texas and the federal Constitution. The U.S. Constitution says, "Nor shall private property be taken for public use without just compensation." The Texas Constitution says, "No person's property shall be taken, damaged, or destroyed for or applied to public use without adequate compensation being made." And so you can kind of break that down into sort of 3 elements when you're looking at eminent domain. The first one is the person who's taking the property. It has to either be the state or a private entity that the state has granted the power to condemn. We'll talk about that. That's where things get a little bit controversial, I think, and we'll spend some time there in a minute. The second thing is the property must be taken for public use. The law, the state can't come in and take private property for the benefit of, one person, another landowner, for example, but they can take it if it's for the public use. And then if that's going to happen, the landowner is entitled to adequate compensation. So I've heard it said this way, and this is probably pretty accurate. It's their right to come in and take your property, and if they meet those requirements, you can't prevent them from taking it. That's true. You can get adequate compensation, and I would go a step further and say you can negotiate some really favorable terms to protect yourself and the rest of your property as well. So that's kind of what we're going to be looking at today. So just briefly, what can be condemned? Well, it's the amount of property that's reasonably necessary for a public use. What's reasonably necessary? I'll tell you, courts really kind of defer usually to the entity that's wanting to do the condemnation in figuring that out, right? So, I guess obviously, right, if you're looking at what's reasonable for them to condemn to take, if you're going to build, for hypothetical example, a high-speed rail might look very different than if they were going to put in, a 30-inch pipeline. But reasonably necessary, courts are pretty deferential on that. They can condemn land. Very frequently, they condemn easements across land. They can condemn improvements. They can actually condemn water rights. To do that, there's kind of a separate statute and some extra hoops that they have to jump through, but that can happen. The other thing I'll mention is that a regulation can sometimes be a taking. If that regulation infringes substantially on a private property right. And so those cases are called generally inverse condemnation. And the way they come up is this. Right, normally for eminent domain, if they're going to take an easement to put a pipeline, the company contacts you, tells you about it, makes you an offer to pay. But if the state or some sort of state entity or agency enacts a regulation that you think has resulted in a taking of your property, generally it's you, the landowner, who would file suit against the state claiming that they took your private property without paying you. And so the lawsuits there generally are seeking the adequate compensation that the landowner thinks they're entitled to. So one just example of that is a water law case that came out several years ago, Bragg versus the Edwards Aquifer Authority. In that case, the landowner argued that the regulations promulgated by the Edwards Aquifer Authority basically took his rights to the groundwater, which he has an ownership interest in beneath his property. And the trial court and the Fourth Circuit both affirmed that and said that regulation was a taking. And he was entitled to just compensation. So I just want you to be aware that that sometimes does happen. So who can condemn property? Look, everybody's pretty, I don't know that we like it, but I think we at least kind of understand that the state has the right to condemn property, right? If TxDOT's going to build a road, we kind of understand they have the right to condemn the property. Again, we may not like it, but we think they can, we understand that they can do it. Where it gets trickier is that if you are a private for-profit entity that has been granted the power of eminent domain under the law, right? It would be like a state statute to give them that eminent domain power. Private entities can take property subject to eminent domain. And that's where you'll see people kind of fired up, right? Pipeline companies are probably the most common example, right? If you've got whoever, Valero or Exxon or one of those companies that clearly is a private for-profit entity, a lot of people get fired up with the idea that they can use the state power of eminent domain. If they're a common carrier pipeline in Texas, they've been granted that power, for example. Another example, and we're going to keep using this hypothetical because it's been in the news as recent as this week, is the high-speed rail, right? There's some legal battles going on, and it will probably land at the Texas Supreme Court next, about whether or not the company wanting to build the high-speed rail which is certainly a private entity, has eminent domain power, right? Does it fit under a statute that allows that for certain railroad companies or interurban railroad companies? That's a question there. Okay, so if you're looking to see if a private entity does actually have eminent domain power, one place you can check is the Texas Comptroller's Office, and they keep a database. It's online. You can go look up any company to see if they have been granted eminent domain power under Texas law. Again, generally what you'll see is a statute that gives a certain class or category of companies that power, and then they have to, fit under that statute to have it. Again, examples of this are the government, public utilities, common carrier pipelines, natural gas pipelines, those sorts of things. Common carrier pipelines is probably the thing I get the most questions on as far as why in the world can this company do this? Well, there's a statute is why. And so if you've got a company that owns or operates a pipeline that transports oil products, gas, coal, carbon dioxide, or other mineral solutions for hire, they're considered a common carrier pipeline, okay? And under Texas law, they've got the power of eminent domain. The idea of transporting a product for hire implies that there will be a customer other than the pipeline owner itself, all right? In order to get this power, what the companies have to do, they got to fill out what's called a T4 at the Texas Railroad Commission. You guys are probably all familiar. I get a lot of questions from out-of-state reporters about why the Railroad Commission is regulating oil and gas. That's just Texas, okay? And so if you want to have the power of eminent domain as a common carrier pipeline, you got to fill out this form. You've got to provide a little bit of information, some documentation, an affidavit, but real basically you kind of check the box, give them minimal information, and that gives you the right to take property as a common carrier pipeline. There's been a lot of complaints about that over the years. That has not changed. The Railroad Commission takes the position that it is not their jurisdiction to investigate those or determine whether or not companies actually are common carriers. That's something that you can challenge in court much later in the process, but that's sort of how that comes up. Just by way of example, okay, let's say that a pipeline company A has a pipeline that runs from Amarillo to Dallas, okay? If it's only company A's product that flows through that line, they're not a common carrier, okay? And that wouldn't give them eminent domain power. But if company A built a pipeline and it let company C, D, and E all run product through that line as well, now company A is a common carrier. Now they have eminent domain power, okay? So that's how that works. Okay, so that's sort of who can take. Let's look now at what's a public use, because remember they said that property can be taken for a public use. The definition that we have is ownership, use, and enjoyment of the property by the state, a political subdivision, the public at large, or entities granted the power of eminent domain. That's pretty broad, right? What you see there, again, common carrier pipelines, natural gas pipelines, utility pipelines, electric lines, transmission lines, water supply projects, highways, hospitals, schools, okay, all those have been deemed to be public uses. And frankly, I'll just tell you that the definition of public use has been interpreted pretty broadly. That's a tough one to challenge, right? If you think the taking is not a public use, you got kind of a long road to hoe there in order to succeed on that challenge. I'm not saying you never would, but it's just the courts are pretty lenient on that standard. There was a case that came out of the Texas Supreme Court last year that involved the city of Rowlett, and kind of long story short, if you want to read more details, I did a blog on it, but there was a landowner that owned kind of a retail establishment, and next door they were putting in a Sprouts grocery store. And Sprouts had been unable to agree with that neighboring landowner to get an easement, to like access easement across this guy's property to connect them to a main road. The city came in and decided, well, we're just going to condemn a access easement for the grocery store. And there was a big argument about, whether or not that was something eminent domain could be allowed for. what was that public use, or was that just to benefit the one grocery store? And the Supreme Court affirmed the decision that it was public use, and that was allowed to happen. So again, pretty broad definition. That's a tough challenge to win. So that's kind of the background on the law. All right, let's turn now and talk a little bit about the condemnation process. And again, just a reminder, if you've got questions, type them in the chat box. I'm sure glad to answer those as we go, and I'm going to leave some time at the end as well. Okay, the condemnation process is just kind of the legal mechanism by which land is taken and compensation is determined when eminent domain is allowed. I think you can kind of break this into 4 sections. There's offer and negotiations, the condemnation filing, the special commissioner's hearing, and then potential objections and appeals. So let's look at each of these. So I said 4 steps, but I'm going to throw one extra thing in here. I call it step 0, and that's the right to survey. I include this because I get a lot of questions. Landowners will call me really upset saying that this company, says they have the right to come on my land and survey, and I don't want them here. I've got phone calls where there have been confrontations at the gate with firearms drawn. So I think it's important just for you to be aware of what the law says with regard to the right to survey. A quote from one of the leading cases on this says, ancillary to the power of eminent domain is the authority to enter upon the land and make a preliminary survey. So in other words, if a company has eminent domain power, that gives them the power to make preliminary surveys. You may not like it until that law is changed. That's what we got, okay? There's some case law on this that limits what they can do to visual inspections and lineal surveys. They cannot do core drilling or subsurface testing or some of the more invasive kind of tests that they might want to do. So that's something just to be aware of. If you're a landowner who refuses to let them access the property, generally what will happen is the company will go and seek an injunction that prevents you from interfering with their right to survey. If they have eminent domain power, that injunction will get granted and they'll have the right to access it. And so this is where you may have to do some strategic thinking, right? Is this a hill you want to die on when you're gonna lose, and there might be better arguments to really dig your heels in on later? Something to at least think about at the time. Now, what can you do and should you do is seek a right of entry permit from that company. What that is just a brief kind of contractual agreement that allows them to enter the property to do their survey, but put some limitations and some requirements on the company. One thing that a lot of people want is some sort of notice prior to them entering the property. So, they have to give you 48 hours notice or something like that. Require access at a mutually agreeable time for the company and the landowner. I got a real angry phone call one time when the company decided they wanted to come out and survey opening weekend of deer season. That wasn't ideal for the landowner, and so that was something that he really wanted some say on. You can try to limit the right of entry only to the property that's going to be affected by the project. Limit the entry only for the purpose of conducting surveys. Make very clear that's the only thing they have the right to do. You may want to put a provision in there that prohibits the cutting, removing, or relocating of any fences. A requirement that they restore the land to the original condition prior to the survey. I mean, look, unless they do something wrong, there really shouldn't be any restoration that has to happen, right? If they just go out and do like a visual and a lineal survey, but doesn't hurt to have that in there in case something does happen. Require all equipment and tools to be removed by a certain date. Require the company to promptly repair or remediate any damage that they cause on the property. Provide an indemnification provision in favor of the landowner. That's big, right? Because what you want is something from the company that says, if somebody gets injured out there doing the survey, the landowner is not liable and we will indemnify, right? We'll hold the landowner harmless in the event that something does happen. Another thing that you can ask for, I think this is a good idea, is ask for all non-privileged information that they collect. So for example, if they do a survey, or if they do some sort of report or map, require the company to give that to you for free, right? We had to pay a surveyor. We bought some land recently, and dang, it would have been nice if we had had a new survey we could have used. So that's something that you can ask for as well. You also want to have an expiration date on that right of entry so that there's a limited time frame as to when they're allowed to come on the property. Okay, so that's the right to survey. And again, that's only for companies that have eminent domain power. If it's a company that doesn't have that power, they don't have any automatic right to enter and survey. Okay, so step one of the condemnation process, you're going to get an initial offer to purchase. Sometimes that'll be in writing. Sometimes that may be like a right-of-way agent coming to your door. So that's how it sort of starts. You'll figure out that they're looking at the property, they're looking at potentially putting in, a pipeline or a road or something. And under the statutes, they have to give you an initial written offer to purchase. So all of this procedure that we're going to talk about comes from Chapter 21 of the Property Code, and it's the same regardless of what kind of project there is. Okay, so they have to give you an initial written offer to purchase. They have to include a copy of any recent appraisals they have had done on the land, and they have to give you a copy of the Texas Landowner Bill of Rights. That's a document that was put together by the Comptroller's Office that's sort of like the Bible on eminent domain. And so anybody who's potentially dealing with any sort of eminent domain, you sure want to Google it and have a copy of that Bill of Rights in your possession. Okay, so they'll make that initial written offer to purchase. That kind of starts the negotiation between the parties. And this is the time where you can go back and forth with the company on things like how much money they're going to pay you, on terms you might want, right? I mean, that can be anything from where the pipeline is going to be located, how many pipelines, what kind of fence is going to be around it, etc. One thing to know is that if they're using eminent domain, they cannot require the terms to be confidential. Which means, right, if you want to go talk to your neighbor who's up the way and the line's going to cross them too, you guys could get together and figure out what they're offering each of you and try to use that as some leverage. Certainly at this point, you can hire an attorney or an appraiser. I'd really recommend using an attorney, to be frank with you. There are things in the law that you can do yourself. I don't think you need a lawyer for everything. Eminent domain is important enough that I sure think that you want to use an attorney here. So that's just my 2 cents on that. So you'll negotiate back and forth for a while. At least 30 days after that initial written offer, you will get a final written offer from the company. They are going to have to give you a written appraisal, and their offer has to be for more than that appraisal. Now, they get to choose the appraiser and they pay them. So I'll let you guess whether you are going to agree with that appraisal or not, necessarily. But you're going to have to get a final written offer. And again, that's got to be 30 days after the initial offer. And then once you get that final offer, they have to give you 14 days to respond. All right, so what that needs to tell you is this. You have a minimum of 44 days from that first offer until they can go file a condemnation suit in court. Don't panic and think you have to sign the first thing they stick in front of you, because they're really good sometimes at trying to rush people. Right? Like, we're moving today and we got to have this today, and man, this is as good as the offer's going to get. It might go down if you wait. No. You have 44 days, again, to try to negotiate, to try and work with an attorney, try to get terms, do some poking around with appraisers and see if you ought to be getting more money, etc. So just keep that time frame in mind. Okay, so during this time, if you're able to reach an agreement between you and the company, right, you agree on the dollar amount, you agree on the terms of the easement, then they'll do a written easement, you'll sign off on it, it'll get filed in the deed records, you get your money, and everybody walks away, right? We've got an agreement. If there is not an agreement, that's the point 14 days after that final offer, the company can go file a condemnation action in court. And this scares people, right? Like, oh my gosh, I'm going to be sued. I'm going to be named a defendant in a lawsuit. Yes, but it doesn't mean you did anything wrong. Okay, that's just how the process works. And I've heard some eminent domain lawyers tell me that the negotiations don't really even get good and the company doesn't really get serious until that lawsuit has been filed. So all that to say, don't panic if this lawsuit gets filed and think, oh, I'm a bad person, or oh, I'm going to lose, or whatever. This is not like a regular lawsuit, okay? It's going to be filed in the district court or the county court at law where the property is located, okay? And so once that lawsuit gets filed, what the judge is going to do is he or she is going to assign 3 special commissioners, okay? These are not the county commissioners, all right? 2 different things. The judge is going to choose 3 local landowners and appoint them to act as special commissioners. Those special commissioners are going to hold a hearing and they're going to decide what amount of compensation you are entitled to. That's all they're going to look at. They're not going to decide if this is for a public use or if the pipeline company is a common carrier. They're not going to look at any of that. Only how much compensation are you owed. Okay, it's a real informal hearing because, you know, they're not actually judges, they're landowners. You'll get a notice from the court that lets you know when the hearing is. You have the right to either attend or not. You have the right to present evidence or not. And there are some real strategic decisions to be made there about whether or not you want to attend the hearing and what evidence you may want to present. Again, that's where I think working with a lawyer is really important because there can be some implications there that may matter. So once that hearing has taken place, the commissioners have heard evidence from the pipeline company, potentially from the landowner as well. They will enter an award and they'll sort of set how much just compensation they think that you are owed. Okay. Once that happens, they will send that back to the court. Okay. It gets filed in the court proceedings. All right. And this is another piece, kind of like the survey, that people don't like. Once they have set an amount, if the condemner posts a bond with the court in that amount, he or she has the right to take possession of the property. Now, this is where people get a little upset, right? What I'm saying is you have the special commissioner's court. You haven't even been in front of a judge yet. You haven't even got to argue about things like, are they a common carrier or is it a public use? And they get to take possession of the property and they can actually start putting the pipe in the ground. Okay, that's how the law works. I didn't write it. Okay, so once that special commissioner's award is filed, either party has the right to file objections to it. Okay, so either the company or the landowner can object to the special commissioner's award. If that happens, there will be a formal trial in the court, right, that will be presided over by a judge. That's where finally you can challenge things like the right to condemn, public use, those sorts of things. They'll have a trial, there will be a verdict issued in that trial, and then the appellate process is just like any other court case, and either party could appeal to the Court of Appeals and then potentially could seek review from the Texas Supreme Court. Okay, that's kind of the process. Let's look at some of the negotiation tips. I said this before, but I'm going to say it again because I just think it's so important. You don't want to panic and sign the first piece of paper that they put in front of you, because I'll just all but guarantee you the amount is lower than you can get them to pay, and it does not have the terms in there that you need to protect yourself. All right, and does anybody know the percentage of how many people sign that first piece of paper? It's about 70 to 80%, right? And so I'm just thinking from the condemner perspective, if I know that 70 or 80% of people are going to sign the first offer, what am I going to do, right? I'm kind of incentivized not to make a super high first offer because they're going to take it, right? And then I'll use all the money I just saved to pay off the people that push back. So, and again, and I know you get panicky, right? Because they're telling you got to hurry. They're telling you they're going to file a lawsuit. Don't panic. There's plenty of things to negotiate. One of those things is the money, right? How much compensation you're entitled to, and that's a big deal. But I want you to keep in mind that there's more to consider than just the money. A friend of mine does a lot of eminent domain work, and he told me on a podcast that I did with him, he said, the thing is, your grandchildren are never going to see the money from that easement, but they're going to be saddled with the terms of it likely forever, right? And so you really want to think about things besides just the money. Again, I really do recommend using an attorney in this scenario to help you with the negotiation process. Here's just a few terms to consider. In that handbook I mentioned that I wrote for Texas Farm Bureau, there's a kind of a checklist in there of terms, so that goes into more detail. Kind of the biggest thing is you don't want to sign a blanket easement, right? And if you've ever looked up the old easements that may be on your property, they're probably blankets. And they'll say things like, the landowner grants the pipeline company an easement to lay pipelines over and through the grantor's land. Well, great. That tells us nothing and limits them not at all, right? How wide can that be? Wide as they want. How many pipelines? Many as they want. Where is it going to go? Wherever they want, right? So you really want to put some limitations in there on that with a lot of detail for sure. And another thing here, get every promise, every agreement, every representation needs to be in writing. Do not just rely on what the company says, because whatever verbal promise they make, if it's not in writing, you probably can't enforce it. And so that's where those sorts of things have to be in the easement itself. When you're looking at terms to consider, put a provision in there that sets forth the width of the easement and the depth of the pipeline. The width of the easement, man, we've had cases on that recently, a couple here in Texas, where there were these old blanket easements that didn't specify the width. And, historically, there was a case in East Texas where they had a transmission line on the property, and for years it was like wooden poles, and they had only used about 30 feet width of an easement. They came back a few years ago and decided they were going to upgrade that line and put in the big like metal towers, and now they want 100-foot easement and not 30. And there was a big fight, a lawsuit about that, and the Texas Supreme Court ruled that they were entitled to the 100 feet because the easement was silent. They wouldn't kind of impose the historic width or anything. So writing those terms in, super important. You want to set the specific location of the easement, whether that's a road or a pipeline. You want to know where that's going to be. The number and types of pipelines or electric lines or transmission lines that can be placed in the easement, right? If you're going to grant them an easement, you want it to be for one pipeline. And then if they're going to come in and put a second pipeline, what do they have to do? Get a second easement and pay you a second time, right? For pipelines, you may want to think about requiring the double ditch method. That's just a way to dig the trench that makes sure your topsoil remains on the top and doesn't get buried. You may want to seek payment on a per square foot rather than a per rod basis. A lot of times with roads and pipelines both, you'll see them make you a per rod offer, right? And a rod is a measurement of length, right? It's like 16 feet. What a rod doesn't take into account is the width, which means per rod, you would get the same compensation for a 30-foot easement or a 300-foot easement, right? Because it's the width that's different. So payment by square foot can help there. If there's going to be any surface facilities on the property, you want to know about those, and you should be asking for additional compensation for those surface facilities. You may also want some say on where those are going to be. Points of access to the property and notice of entry, you can require them, you can enter in a certain gate. You have to notify us before you're going to come on the property, those sorts of things. One thing you can ask for, I don't know if you'll get it, but you could ask for them to pay some portion of your negotiation costs or legal fees. I don't know that I've necessarily seen it with a pipeline. I have seen wind companies, though, that have said, well, we'll give you X amount to put toward a lawyer to review the lease. So that might be something to ask for. You'll probably need or see a construction schedule and a temporary work easement. That's pretty common, right? So let's say that they're going to have a 100-foot easement, but if they're going to build a pipeline, they're going to have to bring like heavy equipment out there to actually like trench it and put the pipe in the ground. They're going to need more space to do that. And so that temporary work easement just gives them that extra space. You do want to limit how long that lasts to where that, you know, they're not out there forever using it. You may want to address the landowner's right to use the surface of the easement once the construction's complete. You know, in general, like out in the country, right, on the property that we own, that's not that big of a deal. We've got a bunch of pipelines and we're happily grazing our cows over it. There are some times, though, where you may not be able to build a structure on it. There may be some limitations on heavy equipment crossing. Could be some limitations on, you know, different things like that. So you want to make sure you spell that out. If there's going to be fences built, you may want to have some specific fencing requirements. You know, how many strands, tensile strength, you know, distance between posts and steel H braces, all kinds of those sort of fence issues. You should make sure that you make specific requirements for the restoration of land damages and maintenance. Right, so if they come out, right, if they're gonna put a pipeline in, they're gonna tear stuff up, and you're gonna want them to restore it as best they can to how it originally was. So that's gonna be things like reseeding the grass and, you know, those sort of details. You want to really spell out how you want that done, right? Like reseeding the grass could mean I threw some seed out there from the pickup window. Or it could mean that they've got to like reseed it and water it until it makes a stand, etc. So those are just details you really want to think about. Another thing is you may want to require a damage payment or a bond be posted up front. That can be real important if it's a company that, you know, kind of goes bankrupt or disappears on you. A lot of easement agreements have a warranty of title clause, which basically says you, landowner, are warrantying to the company that you have the right to grant the easement, like you're the right owner. Well, look, they're the ones that did the title research, and they've got all the lawyers looking at that. Why should the landowner have to guarantee that? So that's something that I would recommend deleting there. Another thing that I get some questions on sometimes is, what about a most favored nations clause? What that is, essentially, it's just a provision in a contract or an easement in this case that says, you know, in the event that somebody else on this same project within a certain distance negotiates a better deal, I get their deal. Pretty unlikely that you're going to get that. I guess I won't say never, but it's not something that you're likely to get. Okay, another thing is you want to think about trying to set a termination standard for that easement. You know, in general, these easements are perpetual, right? They don't have an end date on them. So it's not like a wind lease or a solar lease that lasts for so many years. They kind of last forever. And sometimes people will argue, well, it's abandoned, and so the easement should end. Well, the law says that for an easement to be abandoned, there has to be both non-use and some sort of affirmative intent never to use it again. Well, you know, companies aren't running around signing papers that say we're never going to use this easement again, especially if it's some sort of blanket easement that would let them come back in 20 years and do something, right? So you can kind of cure that problem by trying to set a specific objective standard, right? You could try for a certain number of years. You could try for, you know, a pipeline, something like the easement will terminate when the company fails to move product through the line for, you know, 2 years or 6 months or whatever. I mean, anything you can get would be better than nothing there. So think about that. Kind of our last section here deals with adequate compensation. And remember, under the law, right, they got the power to condemn, but they have to pay you adequate compensation. What does that mean? Well, it's the market value of the property at the time of the special commissioner's hearing. Okay, so when you think about kind of the whole drawn out process there, they kind of pinpoint that date. It's the value of the property at the time of the hearing. Okay, and they kind of look at a couple different tests. The courts will talk about the willing buyer, willing seller test. How much would this property be worth if there was a willing buyer and a willing seller? Now, we know that a lot of times in eminent domain, there's not a willing seller, so that seems a little bit of a strange test, but that's one that courts use. They'll also talk about the value before the condemnation and the value after. So when you think about like an easement, what was the value of the property before the easement? What's the value after the easement, right? And you get the difference in the kind of change of the property there. One thing they do have to look at is the highest and best use to which the land can reasonably be adapted. That's an important one to keep in mind, and in some factual scenarios, that can make a real difference. Just for example, I've got a friend that does this kind of work, and when he speaks, he puts up a map and he shows an intersection, and there's a wheat field on one corner, and then there's a McDonald's, a car dealership, and a Starbucks on the other corners of this intersection. Well, if you were going to go in and condemn that wheat field, right, or an easement through the wheat field, the company's probably going to try and say that's ag land, right, because that's the use it's been made to. The landowner in that scenario is going to argue, no, that land could reasonably be adapted to commercial use. Look around, that worth is way, the value is way higher because of that. So just keep that in mind. Another real critical thing to look at is the concept of remainder damages. Okay, and this is important, like I say, for easements especially. So let's say, a company comes out and they want to take a 100-foot easement that, a mile down my property. Okay, they are going to have to give me an appraisal for the value of the easement, right? How much is that 100-foot, 1 mile, property worth? They also need to include any sort of damages that may be caused to the remainder of my property that they're not taking, but that is damaged as a result of that easement. And depending on your scenario, that may be nothing, or it may be millions of dollars. And that's where you want to make sure you're thinking about any remainder damages. Potentially, they could have to pay moving expenses or relocation assistance if they condemn a residence. Potentially, you can get court costs. There is nothing that really allows you to get attorney or appraiser fees from the company as part of adequate compensation. And that's a rub that a lot of the landowner groups in Texas have had. There have been legislative attempts to change that, but so if the company comes in and lowballs you an offer, you don't take it, you end up having to go to court and pay a lawyer, thousands of dollars to get you what you were entitled to, right? You win. They say, yeah, company, you lowballed them, but then you've got to pay the lawyer. Have you been made whole, right? The landowner groups would sure argue you haven't and would like to see some sort of attorney fee provision, if you got so much more than the offer or something like that. So far, that legislation hasn't gone anywhere. Okay, the last kind of thing I'll talk about on damages, and then we'll get to some resources and some questions from you all, is just a case that came out of Johnson County several years ago. There was some commercially zoned property on Highway 287 in Johnson County. The pipeline company wanted a 20-foot wide, 1 mile long easement and offered $80,000. And the parties didn't really argue much that the 20 feet, 1 mile strip was worth about $80,000. But they couldn't agree on remainder damages. And so the landowner said, no, we're not taking $80,000. The company files a condemnation lawsuit. The special commissioners essentially award $80,000. I don't think the landowner went to the hearing. The landowner hired an attorney and appealed that verdict. They go before a jury, and the jury awards $1.6 million. Okay, the biggest chunk of that, $1.3 million, was remainder damages. And the reason was, right, we're a commercially zoned area on Highway 287, and the easement was going to block the direct highway access to the property, right? And when you think about the value of that, right, the damage to the remaining property when you don't have access to 287 for commercial property, that was a big difference there. So that's just an example of how remainder damages can kind of work. Okay, so with that, we've got, I think, about 15 minutes left. So I'm going to give you just a couple of the resources that I've mentioned. This is my blog. So it's just a website where I post info about ag law. So anytime I do a checklist or a handbook, it gets posted here. Anytime a new case comes out and I write about it, that's going to go here. So if you're interested in ag law, I hope you'll think about subscribing. When you go to that website, or you can just Google the name and it'll come up, a box pops up, and I know that's annoying, okay? But you can put your email address in there and click submit, and that's going to subscribe you where anytime I do a post, it comes directly to your email. So you don't have to worry about coming in and look on the blog.
Tiffany, we lost your sound there.
Material.
Can't hear.
Tiffany, you've kind of dropped out of sight on sound.
Yeah, I think her internet's cycling out, so maybe she'll be back.
Sorry, guys.
All right, now you're back.
Okay, I'm gonna share my screen. Sorry about that. I don't know what happened there. Share. Okay, I mentioned about the blog. I hope you heard that. I've also got some additional programs coming up hopefully this fall, if we are allowed to travel again by then. We do an Owning Your Piece of Texas program. I know this isn't super close to where you all are located in Montague County, but it's a day-long ag law program where we basically go over the key laws Texas landowners need to know. So we'll do everything from fence law, water law, landowner liability, eminent domain. So that's something, if you're interested in, you can check out those programs. The registration info is there. We also do some half-day ranchers leasing workshops. We've got several of those coming this fall. We really focus in on legal and economic issues related to grazing, hunting, and livestock leases. Also spend a good amount of time on landowner liability there as well. So you can see the list of live programs. We also recently launched an online course. And so the benefit of that is you can take it anytime from your own home. It's videos of us presenting. We went to a studio and did that. You can watch it anytime you want, as many times as you want, whenever you want. So if you're interested in that, shoot me an email and I'll get you the info on how to sign up for that. The last thing is the podcast. I mentioned this at the beginning. We've done about 80 episodes. So every show I just interview an ag lawyer on a different topic. Several related to eminent domain, guys. So if you're interested in that, I'd really recommend them. In fact, my most downloaded podcast is called FAQs of Eminent Domain. So you can check that out. If you're a podcast listener, we're on iTunes and Stitcher and all the places like that you could listen. If you're not, you can listen on your computer. All you have to do is go to that address at the top, aglaw.libsyn.com. Type that in, okay, and it will automatically take you to the page. All you have to do is scroll down to find the topic you want and push play, and it'll play on the computer. It's just audio, no video for those. So with that, here's my last slide. That's got all my contact info. There's my email. Right now, since I'm working remotely, that's the best way to get a hold of me. I'm on Twitter and Facebook if you do social media. Feel free to reach out there as well. So with that, I will take any questions that you might have. I don't see any in the chat box, but if you all have them now, just type them in, and I'll be glad to address those.
Well, and Tiffany's really good about, getting back with you on email and everything and trying to answer those questions, or if you need to submit it to me and I can forward it on to Tiffany as well. Those blogs or those podcasts, are real good information to listen to going down the highway or something like that. It sure kind of helps pass the time as well. But again, Tiffany's pretty sharp on all this stuff, not only on this, but several other topics as well. So I'll give her kudos for that. And we're glad to have her here with the extension. But yeah, if you have any questions, please feel free to ask and we'll kind of go from there. If not, we'll let her go and everybody continue through their lunch hour then. I know somebody put in the chat to me, will we be sharing some of this? Yes, we've recorded it. Well, there's also a slide set, if Tiffany will allow me to share that slide set, that is. But
yeah, absolutely.
Okay, so it has been recorded. So if anybody has requests for any of that, we'd sure send it to them as well. I'm assuming I can get to my recording at some point in time. I guess Tiffany's recording on her end as well. But so hopefully we can get all this to you in one way or another, but we at least have the slide set. Well, it appears that we don't have many questions, Tiffany. Have you got any other last pointers that you'd like to give us or anything? Or
No, I don't think so. But like you said, if you guys have questions on this or any other topic, feel free to shoot me an email. We will make sure that Brent and Justin have the slides and they can make sure to email those to you all if that would be helpful. Like I say, if this is a topic you're interested in, I really think that new handbook we did is useful. I really would push, there's 2 podcasts in particular, one with Zach Brady and one with Luke Ellis that deal with eminent domain. I just think those are really valuable resources for landowners. I mean, getting to pick the brains of 2 of the top eminent domain lawyers in Texas for free, hard to beat that. So just make sure you check those out if that's a topic you're interested in.
All right. It looks like everybody enjoyed it, Tiffany, so appreciate you. Unless anybody has a last minute question. Susan, if you got one, your mic came on, but I don't know if you've got one. Okay. All right. Looks like everybody's logging out then. So Tiffany, again, I appreciate you. Brent, thank you for helping us with this again one more time. And
Oh, you bet. Yeah, thank you, Tiffany. You always do a wonderful job, whether it's face-to-face or online or whatever you're doing. We certainly appreciate you.
Thanks, Brent. Thank you for being the Wizard of Oz behind the curtain there. We appreciate that.
Yeah, no kidding.
Well, I've kind of started doing that mainly to, in case something happens.